Check now the best anti-stress solution for your everyday life. Click the link in the description for your anti-stress solution.
Trump weighs revised travel ban, Supreme Court test still possible. President Donald Trump said late on Friday aboard Air Force One that he is considering issuing a new travel ban executive order, while White House Chief of Staff Reince Priebus said the administration could still escalate a legal dispute over Trump's original travel ban order to the U.S. Supreme Court. In a step that triggered the most serious legal confrontation yet for the new Republican administration, Trump 2 weeks ago issued an executive order banning entry into the United States by refugees and citizens of 7 Muslim-majority countries, triggering nationwide protests and legal challenges. A federal judge in Seattle last week issued a temporary restraining order putting the travel ban on hold. That suspension was upheld by an appeals court in San Francisco on Thursday, raising questions about Trump's next step. In a surprise visit with reporters aboard Air Force One en route to Florida from Washington, Trump said he was considering a brand new order that could be issued as soon as Monday or Tuesday if he decides to move in that direction. After a White House official said the administration was not planning to escalate the legal dispute to the Supreme Court, Priebus told reporters late on Friday such a move was still possible. Every single court option is on the table, including an appeal of the Ninth Circuit decision on the TRO, temporary restraining order, to the Supreme Court, including fighting out this case on the merits, Priebus said. And, in addition to that, we're pursuing executive orders right now that we expect to be enacted soon that will further protect Americans from terrorism. Trump's order, which he called a national security measure meant to head off attacks by Islamist militants, barred people from Iran, Iraq, Libya, Somalia, Sudan, Syria and Yemen from entering for 90 days and all refugees for 120 days, except refugees from Syria, who are banned indefinitely. Trump could rewrite the order to explicitly exclude green card holders, or permanent residents, said a congressional aide familiar with the matter who asked not to be identified. Doing that could alleviate some concerns with the original order expressed by judges in the Ninth Circuit Court where it is being tested. On Air Force One, Trump said regarding the Ninth Circuit Court fight, "We will win that battle. The unfortunate part is that it takes time statutorily. We need speed for reasons of security." An official familiar with Trump's plans said if the order is rewritten, among those involved would likely be White House aide Stephen Miller, who was involved in drafting the original order, as well as officials of the National Security Council, Justice Department and Department of Homeland Security. Independently of the Trump administration, an unidentified judge on the Ninth Circuit requested that the court's 25 full-time judges vote on whether the temporary block of Trump's travel ban should be reheard before an 11-judge panel, known as en banc review, according to a court order. Trump looks at new immigration order, no Supreme Court appeal. U.S. President Donald Trump said late on Friday he is considering issuing a new travel ban executive order, while a White House official said the administration did not plan to escalate a legal dispute over Trump's original travel ban order to the Supreme Court. Trump's original order banning entry to the United States by refugees and citizens of 7 Muslim-majority countries was put on hold by a federal judge in Seattle last week with a temporary restraining order, and that suspension was upheld by an appeals court in San Francisco on Thursday. Trump said during a surprise visit with reporters aboard Air Force One en route to Florida from Washington that he was considering a brand new order that could be issued as soon as Monday or Tuesday if the administration decides to move in that direction. The White House official separately said, "We are actively considering changes or other executive orders that will keep our country safe from terrorism." The official said, "The temporary restraining order, we would not take to the Supreme Court, but we are reviewing all options in the court system." In Trump travel ban fight, Justice Kennedy's 2015 opinion looms large. Justice Anthony Kennedy's legal reasoning in a 2015 immigration case suggests the U.S. Supreme Court's frequent swing vote would be skeptical of President Donald Trump's travel ban on people from 7 Muslim-majority countries. The little-noticed case involved an Afghan-born naturalized U.S. citizen named Fauza Din who argued she had the right for a full explanation from the U.S. government as to why her Afghan husband was denied entry. The justices ruled 5-4 against her. Kennedy wrote in a concurring opinion that in some circumstances the U.S. government's motives in denying someone entry could be subject to legal review. In their lawsuit challenging Trump's January 27 ban, the states of Washington and Minnesota cited Kennedy's opinion. Lower courts have temporarily blocked the ban, but the administration may ask the Supreme Court to revive it. Trump's executive order barred entry for citizens from Iran, Iraq, Libya, Somalia, Sudan, Syria and Yemen for 90 days and imposed a 120-day halt on all refugees, except refugees from Syria who are barred indefinitely. Curbing entry to the United States as a national security measure was a central premise of Trump's 2016 presidential campaign, originally proposed as a temporary ban on all Muslims. He has voiced frustration at the legal challenge to his order. Washington and Minnesota argued that Trump's order violated the U.S. Constitution by discriminating against Muslims. Trump during the presidential campaign called for a total and complete shutdown of Muslims entering the United States. In the 2015 case, Din, who lives in Fremont, California, sued the U.S. government after her husband, Afghan citizen Kanishka Barashk, was denied a visa in 2009. She objected to the government's visa denial under a law giving consular officials wide discretion to bar people linked to terrorist activities. The High Court's ruling overturned a 9th U.S. Circuit Court of Appeals decision that said Din was right to insist the government give her more information about the visa denial. Kennedy's opinion suggested he could be willing to dig into the Trump administration's rationale for the order, said Mark Haddad, the Los Angeles-based lawyer who represented Din in the 2015 case. The ostensible reason for the travel ban is security, but that's not a good faith concern if the underlying reason is religious animus, Haddad said. Total deference. Kennedy's opinion showed he is not prepared to give complete and total deference to the executive branch in the enforcement of immigration laws, Haddad added. Samuel Alito, one of the court's most conservative justices, signed on to Kennedy's opinion. In total, 6 of the current 8 justices suggested in that 2015 case that the government was not immune from scrutiny over immigration-related decisions if there was evidence of a questionable motive. The case brought by Washington and Minnesota, or one of several similar disputes around the country, could reach the High Court quickly in the wake of Thursday's decision by a 3-judge panel of the San Francisco-based 9th Circuit upholding a Seattle district judge's decision to block Trump's order. The Trump administration would need to win the support of 5 of the current 8 justices to reinstate the order while litigation over the legality of the directive continues. It could also seek to end the litigation by issuing a new order. Neil Gorsuch, Trump's nominee to fill a lingering vacancy, is awaiting Senate confirmation hearings and is unlikely to be seated on the court for at least 2 months. The 2015 case, called Kerry v. Din, was cited both by the challenging states and the Trump administration in their court fight. Washington state's lawyers argued Kennedy's opinion shows that courts must look at what motivated the government's decision beyond the words that appear in the order itself. They cited the previous comments by Trump and others expressing a desire to keep Muslims from entering the United States. The administration noted in court papers Kennedy also made it clear that the government is entitled to deference, especially on national security. Ann L. Callahan, an immigration law professor at Drexel University's Klein School of Law in Philadelphia, said there are multiple ways of interpreting Kennedy's opinion, which could muddy the waters. Kennedy's opinion doesn't necessarily mean he would reach the same conclusion on Trump's ban, Callahan said. In Tuesday's 9th Circuit oral argument, administration lawyer August Flench called the executive order facially legitimate, meaning there is no need for courts to inquire further into motive. Judge Michelle Friedland immediately pounced, "Haven't there been allegations here of bad faith?" She said Kennedy's opinion in the Din case as well as the 1972 Supreme Court ruling in a case with similar themes envision that's something we should look at. The 1972 case involved professors objecting
to receive more news on our YouTube channel, please click the subscribe button. If you like to receive an alert every time a new upload is made, hit the bell. Give us a like to the video or dislike if you agree or not to the news. Be proactive. Is your life and the news will serve your day. Finally, leave us your opinion in the comment section on what you think about the subject. Thank you and stay tuned to Breaking News 24.